Hi, I'm Chip Rogers, and welcome to the AAHOA Educational Experience. With me this week, three experts in the world of franchising. First, Robert Zarko of the law firm Zarko, Einhorn, Sakowski, and Brito. Next to him, Ron Gardner, who is a managing attorney with Dady & Gardner. And finally, Carmen Caruso with Caruso Kaplan. Gentlemen, first of all, thanks for being here with us and sharing some of your information. We have so far talked in previous shows about how to start a franchise, how to succeed at a franchise, and then once you've got to the point that you want to move along to your next adventure, how to close a franchise, and that's what we're going to talk about today. I can assume that most people, the day they're signing that franchise agreement, are not thinking about the day they're going to sign it away to somebody else. That, I would assume, is a very important thing to think about when you're starting a franchise, is how am I going to close this franchise someday? Robert, what's the most important, what are the things that someone needs to consider on the very front side when thinking about how they're going to close a franchise one day?
Chip, you hit it right on the head. It's unfortunate, but it's a reality that when many people enter into a franchise relationship, in fact, most of them, no one's ever thinking that the business is not going to be successful or that they have to leave the franchise business for any reason in particular. So no one is thinking of what is going to happen if it doesn't work, or what is going to happen if I simply don't want to stay in this business any longer. And that is where, when you sign a franchise agreement, you need to look at the provisions regarding default that set forth what particular conduct may create a problem in the relationship that may cause a termination. You have to read the termination provisions and what are the obligations that you as a franchisee have in terms of post-termination obligations, in terms of what happens to the business, what happens to your ability to use the brand, which you cannot continue to use the brand. There are de-identification procedures. And then you have to look at, in the event a dispute arises as a result of the circumstances that led to a default and a termination, or you as a franchisee have defaulted the franchisor because in your view the franchisor has failed to live up to their contractual obligations, you know, what happens then? What happens in terms of the manner in which a dispute is resolved? Is it resolved through an arbitration? Is it resolved first through an attempt of having a business meeting between the franchisor and the franchisee representatives? Is there a mediation that takes place thereafter? Is there an arbitration, or is there litigation? And what are the differences between the two? Because there are strengths and weaknesses. Every franchisee, before you get into a franchise relationship, needs to understand what happens if the inevitable arises one day and the franchise has to be terminated. How are you going to go through that process? Probably the most important provision that affects franchisees in a circumstance of a termination, or where there is no longer going to be a future relationship with the franchisor under that brand, is the non-competition provision. And the non-competition provision is extremely important because it governs your future after that franchise relationship is terminated. And there's two very important elements of a franchise non-competition provision. One is the duration, or the time in which that non-competition provision applies to. Do you have a non-competition provision that is for 1 year, 2 years, 3 years, maybe 5 years? If you see a duration of a non-competition provision that's 10 years or 15 years, it is very unlikely that a court would uphold that as being reasonable in terms of time. So you have the time element of how long that non-competition provision is. The second element is the scope. How broad is the protection that the franchisor is seeking? Let's say you are in the food business, and the franchisor says you're precluded from participating in any food business for the next 5 years or 3 years for an area of 3 miles or 5 miles or 10 miles or 25 miles. Again, the broader the scope of the mileage or distance, the greater chance you have to challenge it for being commercially unreasonable. But with regard to the scope of the type of business, if you are selling chicken, it may be more reasonable to say, okay, I will not be in the fried chicken business going forward, or I will not be in the taco business. But to say that you're not going to be permitted to be in the food business at all when your whole life for the last 10 or 15 years, this is all you've done, can be very limiting. You must make sure that your attorney that you consult understands, and you understand that there are particular states that govern the non-competition rules and regulations between the franchisor and the franchisee, and that in fact there are many states that protect the franchisors in enforcing those non-competitions, but there are many other states that say that non-competition provisions are in fact not valid, not enforceable. You need to know this up front, because again, in the circumstances and the unfortunate circumstances where the relationship does not continue, as long as you want it to continue, you need to understand your exit strategy.
So the non-compete clause is clearly a very important factor to consider about your future, but the here and now may be liquidated damages. Tell us a little bit about that.
That's right, and this is particularly true for people in the hotel industry, because almost more in the hotel industry than any other industry I can think of that is dominated by franchising. Liquidated damages are a provision in most of the hotel agreements that say that you can leave our system in exchange for payment of money. And we're going to give you a formula. It varies from system to system based on the amount of money you paid us over the average that you paid us over the last 3 years or the last year, and we're going to multiply that by some percentage. And if you will pay us that amount, we'll let you go. And really, on the plus side, as Robert mentioned, a lot of states will enforce non-competes, and if you're in a system that has a non-compete as opposed to a liquidated damages provision, and the franchisor wants to enforce that, it can be devastating to the business, because whether it's 1, 2, or 3 years, frankly, most people can imagine if you have to shut your business for a month, you're almost starting from scratch. So whether it's a year, 3 years, 50 years, you're probably done with. Whereas a liquidated damages provision, if you can come up with the cash and pay it off, is going to allow you to maintain the going value of the business, because you don't ever have to close the doors. The flip side of that, of course, is how much is somebody going to charge you to do this? I mean, is this a reasonable exchange in terms of what was the franchisor going to collect from you if you continued to go, if you continued forward? Under what circumstances are you closing? There are cases out there that suggest that a liquidated damages provision, because what we're trying to do is figure out how much would the franchisor collect if you continued in the system and then paid some percentage of that to allow you to leave. You know, if you're closing because you're going out of business, because you're actually going bankrupt or you have to close, there's some good cases out there that say, well, the liquidated damages provision there shouldn't be much, because if you're going to go out of business, you're not going to be paying anything to the franchisor in the future anyway. So you've got to make sure that there's some reasonable relationship between the amount that you're paying to get out and the amount that you are willing to pay to continue running the brand. You mentioned, Chip, as you were asking the question in terms of thinking about the exit strategy, and we focused so far, I think, on terminations. I think the other piece that I want to throw out there as we're talking about ending the relationship, I mentioned in the last segment about preserving and enhancing the value of the business. Not all franchises end badly, but you still want to preserve and enhance the value of the business. So the other two provisions, besides the non-compete provision that Robert mentioned and the termination, you know, when you're being defaulted, you absolutely have to understand that. The other two pieces that you need to make sure you understand are the transfer provisions. How can you sell the business? What hoops do you have to jump through? Who can your buyers be? How much control does the franchisor have of that? And the renewal provisions, because if you get to the end of your 10-year term or your 5-year term or your 20-year term and you say, hey, you know what, I'm young, I'm spry, I love what I do, can you renew? Because there are a lot of franchises out there that don't allow you to renew or make you really sign away up front all sorts of rights you might have on the back end. So when it comes to exit strategy, think more broadly than I'm being terminated. This is, I'm leaving the business maybe on my own terms. I'm selling to somebody and I'm getting a big return. What do I have to do? What do I need to make sure I can achieve in order to preserve and enhance the value of my business, whether I'm running it or I'm sending it off to give it to somebody else?
Well, we're actually out of time in the first segment. We'll start with you in the next segment. Right. And we've got a lot more to talk about franchising. Great topic today, gentlemen. Thank you for being here. This is the AAHOA Educational Experience, and we'll be back right after this. Hi, I'm Chip Rogers, and welcome back to the AAHOA Educational Experience. We're talking about franchising, and we're talking right this week about exit strategies. What happens when you are moving on for whatever reason? I want to start with Carmen Caruso. And Carmen, we've heard a lot about liquidated damages. We've heard about non-compete clauses. These are something that probably a lot of franchisees don't want to think about. But let's say you get to the end of that time, and whether you're leaving on good terms or you're leaving on bad terms, are those particular items negotiable? And under what circumstances would they be negotiable?
Well, absolutely they are. Let me just say this, though, because when we started the show a couple weeks ago talking about getting into the franchise and planning for the life of your franchise, the best way to leave a franchise is not by having an argument or negotiation on these things like liquidated damages or non-compete. The best way to leave the franchise is by selling it when you've built your equity, you've built the business, and things are going good, and it's the right time to sell, and you cash a nice check, and you go on to the next phase of your life. If that doesn't happen, if you've stuck around because you like the business and you've got all the right reasons, but now it's become an adversarial situation, something has gone wrong, and you're facing the prospect of a termination for whatever reason, and if you're in hotels in particular, you've got to worry about liquidated damages, or if you're in most of the other franchises that don't have liquidated damages but have a non-compete clause. And by the way, it's usually one or the other. It would be really, really bad if someone tried to make you pay a liquidated damage and abide by a non-compete, and that doesn't happen so often. But defending against those clauses is fine, but the best defense is to go on the offense, like so many things in life or sports. Because if the things have gone bad in the relationship, you want to find out, why did things go bad? Was it just the economy? Was it nobody's fault? Or was it the franchisor's failure to deliver? So what I always try and do is get the franchisee to think honestly and thoroughly about, why did we get into this position? And more often than not, I've got something to talk about with the franchisor, to call up their lawyer, and you probably know who they are because you know who represents who and all that, and to talk about this franchisee in this situation, to talk about the breaches of contract that we believe have occurred, so that they know that we're not just negotiating from a position of weakness, that we're begging for something, but that we're threatening, implicitly or expressly as the case may be, that they're going to have trouble enforcing their liquidated damage or non-compete clause because they breached the franchise agreement. And you have to present this case in a way that a judge or an arbitrator will ultimately understand what is fundamentally fair. Which side of this contract lived up to the promises and expectations, and which side didn't? And if we could present our clients as wearing the white hats, the people who did everything right, and the franchisor did not, and now the franchisor wants to take advantage of its own opportunistic or improper behavior and penalize the client, that's a case that we can most often persuade the franchisor to back down and negotiate the way out of the non-compete, and maybe we have to sweeten it with a small check to buy your way out of the non-compete. It's all a matter of negotiation and making an intelligent business decision and being prepared and convincing the franchisor and its legal team that if they don't negotiate or compromise in a way that we and our client believes is reasonable, that we will go to court. And it's all about making the credible, believable threat that we will take you to court or arbitration, wherever the forum is, and that we force them to negotiate. It's the only way.
Robert, we just have a few moments left. Let's talk quickly about state-by-state differences. I mean, we do live in a country where there's 50 different rules to play by. How big is that in determining where you're going to set up a business and how you're going to close a business?
The issue with regard to the differences in the laws of different states, it is an extremely under-considered provision or element of the franchise relationship when franchisees and even their lawyers are looking to get into this relationship. But yet it's probably one of the most significant. You have different franchise statutes in different states. Most states have what they call pre-sale franchise statutes that deal with what a franchisor can and cannot do in the process of selling a franchise. You have, but those states do not have, or many of them may not have what's called a relationship statute. Then there is about 14 or 15 states that have relationship statutes, in addition to pre-sale statutes. So you have the statutes that protect you when you're buying the franchise, then there are statutes that govern the relationship during the time that the relationship exists. Then you have different states that have common laws, which are based on legal precedent, which perhaps apply different legal doctrines differently. You have the doctrine of the implied covenant of good faith and fair dealing, which is a very important doctrine in terms of the franchisor-franchisee relationship. And you would think that that is a doctrine that must exist in every state in this country, but the reality is that there are a few states in this country that do not even acknowledge or recognize the doctrine of the implied covenant of good faith and fair dealing, which in our view, and I'm sure all three of us share in this view, is outrageous that a state law does not require that.
And what it means in California may not be what it means in Texas.
Correct. And as a result, I mentioned earlier in one of the prior episodes how important it is to focus on the miscellaneous provisions, what's typically called the boilerplate provisions in the contract. And those provisions specifically state what the choice of law is that governs the contract. It also dictates in many contracts what the venue is in which if a dispute arises where you have to fight. And that's also going to be a problem because typically the venue is set in the location where the franchisor's headquarters exist. And the reality is, in that situation, that can have a serious impact on the outcome of a case. You must consider what the venue is, what the governing law is. You must consider what the state statutes are in really deciding whether that is the right franchise for you. Again, unfortunately, you never know what's going to happen at the very tail end of the relationship, where it's going to be good at the end or it's going to be bad at the end. The bottom line here is, Chip, there has to be a good relationship established between a franchisee and a franchisor throughout. It's got to be maintained. There has to be open communications, because the reality is all of these franchise agreements have so many terms. They're so all-encompassing that if you really look carefully at every franchise agreement, you will find that the franchisor is in breach of some element of that franchise relationship. You're also going to find that the franchisee, no matter how good he is also in breach of some element of that franchise relationship. And the only thing that protects from both sides from going down the path of destruction is to maintain open communications, good relationships, and approach the problem early on.
We have about 1 minute left. And Ron, I want to get to you. You're cashing out. You've got a good relationship. You're selling your business. What is the very best thing, or the most important things you need to do to make sure you're protecting that business for the family, whether you're cashing out and selling it or whether you're actually giving it to another family member?
Well, make sure that the rights that you have are being able to be passed on. That's going to be important to your successor, particularly if it's a family member. A lot of times franchisors want to change the deal at that point because they've kind of got you. You're standing there ready to take that check, and if they can change the deal in their favor, they would like to do that. Don't be pressured into taking less than the business is worth. A lot of franchisors want to put pressure on the franchisee at the last second, say we want the buyer to keep as much money as he can so he can reinvest. If you make a deal with the buyer and it's a sophisticated buyer, make sure that the franchisor allows you to get your total return on investment. And then the last thing I'd say is to the extent that you can avoid signing a release, so that if something goes bad 3 months from now, you figure out something went wrong, you haven't signed away your rights to go back and try and protect yourself.
Great. Well, that's all the time we have this week. I want to say thank you to the gentlemen that have been with me, Carmen Caruso and Ron Gardner and Robert Zarko. I think you've helped our viewing audience quite a bit on these issues. For the AAHOA Educational Experience, I'm Chip Rogers. We'll see you again next week.